Justice Thursday, our conversations that we have, and we look at the work that the judiciary is doing in the country, and we have the conversations around what some of these increasing or enhancing the access to justice. And we started doing this a while ago, and we've been doing it and actually giving the judiciary a face that Kenyans can resonate with. And this is another Thursday where we have that conversation. Our guest is already seated in the hot seat, and he's in the person of Justice Stephen Riechi, and he's here with us this morning. Good morning. The conversations must continue. So move things around a little bit, but let's now see how we can move forward. This is the Situation Room, dealing with the situation, but let's go. Justice Stephen Riechi is here with us this morning, and we're looking into our Justice Thursday conversation around High Court Succession Service Week and all we essentially need to know. So, let's go at it again. Justice, where we're talking about, succession week, and what exactly, when we hear succession, we hear our minds are so many things passing on: property, taking over from a pair, or who takes up another job. But just let us into that as we get into that conversation.
Thank you very much. As I was saying, that at the family division we handle quite a number of issues. All of them must be related to the family. We handle succession, which we will talk about shortly. We handle adoption, we handle matrimonial property, we handle mental health, issues where persons have suffered a mental illness and there's need to manage their affairs. And we also have some miscellaneous applications, particularly when it comes to surrogacy issues. But today I want us to talk about succession. Every parent, every person will die.
Okay. Yes.
That's not the opening we expected. But okay. But yes.
Methuselah lived for 960 something years, but he eventually died. So all of us will die. So when we talk about succession, we are not talking about the dying bit of it. We are talking about the preparation of the management of your affairs after you are dead. That is basically what we are talking about. And we talk about it because it's important. Every person has, fortunately, or you could be having a family. You could be having some property, you could be having some business, and you have devoted your lifetime to these businesses, and you have accumulated wealth. And the most important wealth you may be leaving behind is that of your dependents, your children, your spouse. It's always a pleasure that you will wish that when you are away, they remain in peace. Your legacy will continue in a very orderly manner. And therefore we're asking that before you do that, can you be able to arrange your affairs before then? And you can do this by 3 ways, and that's what we deal with. One, you can do this by making a will, where you indicate, this is my property, this is my dependents. When I die, please, I want my this property to be distributed to my dependents in this format.
Yes,
that's a will. Then you can also, like most of us, we do not want to think about death. We associate the will with death, and therefore we just leave it. And when we leave it, it means that you'll die intestate, that you have not made a will, and that therefore the court will determine how the property will devolve to your dependents. The third, that is the two main ones. There is an oral will. We have a provision for an oral will in our legislation.
Yeah.
but it's quite limited, because if you have made an oral will, is you call people, tell them these are my children, these are the way I want my property to be distributed, because I'm feeling my days are almost over. But you must also die within 3 months.
Oh, hang on a minute. Okay, sorry. So if you're making this declaration to the members of your family, then if I say that with my millions, no billions, no trillions.
When you were working for stop there.
And I have had a premonition that something is going to happen, and I say that I will leave this property to my 2 husbands and my children, and I've said it, I've spoken it, I have not documented it, then essentially I must pass within 3 months. If I don't pass within 3 months, then what happens?
If you don't die within the 3 months, then you will call us again and tell you I didn't die. I told you to die. I was going to die. I didn't die. But now I want to make another one. Repeat what I said, and then that is how it is. It must last that long.
Why does that timeline exist?
Because it's not written. It's not written. The anticipation is that you are just at the end of it. And we'll prove that oral will in court if it is there. But the first thing is, did you die within the 3 months? No. Or if you didn't, did you renew it?
Is the 3 months just in case the person changes their mind?
No. If you don't
die within 3 months,
yes,
and you have to do it within that time frame.
Yes.
My question is, why 3 months? Why not 4? Why not 2?
I have no idea where the 3 months came from, but the intention is that if you're saying that's in anticipation of immediate death. That's I guess they wanted to consider the one which we have at the old system where you call people, but to avoid that, please do a will written, even if it's you write. Ask somebody come. Write. Even when you are talking to them about this will, let them write, document it, let them have witnesses, and that is all.
In your experience, Justice, what's the extent of testate versus intestate? How many cases are landing on your desk?
Very less than 10% will be tested. The 90% will be where you have died and you have not said anything about what will happen about your estate after you have died.
You haven't done even the oral? You
have not done the oral, you have not done the written, and therefore the matter is left to the court to decide. So that's the bulk of us. That's where we land.
So then that means many Kenyans die without wills.
Yes.
Is this a reflection of legal illiteracy, or is it, for lack of a better word, judiciary's failure to demystify the probate process? Because not so many people understand what goes into doing a will for an ordinary citizen.
Yes, there's two. One, people do not understand why they should do that. There's need for education, but even when you find even people who have been exposed, even them very rarely. Even we sit here, if we ask all the 3 or 4 of us, how many of us have made wills? Thank you. I don't know how many of us could say.
For me, my assumption has always been a will when
in the 3 months before you die.
See, when you start hitting 60, there's a joke, when you start celebrating your birthday in church, you are headed there,
You should have done your will or do it soon after.
So the assumption normally is wills are done by people at least in their old age or sunset years. They have property, they have a lot of these things. But for somebody who just has like a 150 by 100 and he has 5 children, what's the point of writing a will? And maybe a kiosk for selling phones, for example.
There is need, if you have any property, there is need for that, for you to indicate how, in your absence, that property should be discarded, should be devolved. One, it allows you the testamentary freedom to say what you want, who to have what. I mean, that's one. The second one is that it eliminates friction after that. So people will say, look, this is what father has said, and therefore this is what should go on. Very few people, except a few, will want to challenge that, but there is that respect that father said this, and this is what we will go on. So what now happens is, because of the fears like the ones you have, people die without a will. And when they die without a will, the matter now comes to us to administer the estate as intestate. That he has never made a will. He has property. He has dependents. Now they have to come to us and say, look, my father died. He had this property. We need the court to assist us how we want to divide it among ourselves.
But today we have very prominent cases, Justice, of someone has done a will,
yes,
and as they've done their will, it's still, contested. What guarantees that whatever it is that you've actually said in a will is what will be applied, when you leave this world? And, there's also the bit of witnesses also, because we've seen families, we've seen children of these prominent personalities come out and say, I contest that will, it's not my father who did it, it's not this, it's not that. Then it becomes so complicated. So what then are the guarantees that, okay, fine, I'll give my 50 by 100 to my son, I'll give this to my daughter, I'll give this, and that's final?
Yes. In court, when there is a will, a written will, and it's a valid will, we tend to respect it completely. Once we are determined, it can be challenged. The validity of the will can be challenged. He's not the one who wrote it. There were no witnesses. He left me out, and all that sort of things. But at the final decision will be that this will is a valid will. When we do find that this is a valid will, that is what will determine the distribution as per the will. Why? We tend to respect testamentary freedom of the testator. We value that a lot, and we will need. However, where we find that their will is not valid, it was forged, the signature was not his, the witnesses were not genuine, then we say the will is not valid. When the will is not valid, then we revert to the fact that it was intestate. But where it is valid, we don't change anything.
What makes a will valid?
One, it must be written.
Okay.
It must be written, in written.
Handwritten?
No. Yes, handwritten, but if it's drawn by an advocate, that is much better because they understand the language. But even handwritten, written we will. It must be signed by a testator. Okay. The one who is rating the will. It must be signed. There must be 2 witnesses. There must be 2 witnesses who saw the testator signing the will.
And must these 2 witnesses be the immediate family, or it can be anyone?
They don't actually. It's much better if they are not the family members.
Okay, because there's no partisanship.
There's no partisanship.
Okay.
Then he must have, in that will, he must have identified what his properties were, and then he must have identified who the dependents were in the will, and distributed the estate, whatever he had, to the dependents, not necessarily equally, because that is his decision. But he must have taken care of all his dependents. Okay. Then the property which he has mentioned, it must be property which is his. He cannot say, I think Standard Group, I give to you.
It has to be his and proven that it was his own.
Yes, it must be his.
So, I mean, just on the issue of having it written down, it was interesting because yesterday I was watching some legal drama and there was the same kind of issue here. And in court, they said, well, it was written down. It was a piece of paper. It was years old, but it was clear that it was in the handwriting of this gentleman, right? And he didn't even use a pencil. He must have used a kind of chalk or something, but it was in his handwriting.
Yes.
Whereas there were no other witnesses, but what was being contested was whether he actually meant what he said, because he put out quite a sum to somebody who was not in the family. So when you talk about it being written down, what's the threshold for authenticity here when we are saying that if I write something down on a piece of paper or in a book and that there were no witnesses at the time, then are we saying that there's a likelihood of such a thing, should it be brought before a court, it would be thrown out?
The Act, the Law of Succession Act, provides what constitutes a valid will.
Okay.
And one of them is that there must be witnesses.
Okay.
Yes. So if there were not witnesses, then it cannot be valid.
Okay.
Just the writing for you to write in your notebook, kitu nini, and nobody else has said that will not stand the validity of a written will.
That's your personal journal
Yes,
for
that's
your own use.
personal journal.
Yes.
For your own use, yeah.
Justice Riechi, what is the court doing? Because I believe the service week is to help clear pending cases, because of course these delays cost a lot of grief. Which law, which branch of law is used? Because there is the succession and then there is family law. Which is preferable to speed up cases? Which is more affordable? Because also people imagine this is a very expensive process. Yeah.
Let me say, one of the easiest matters to handle are succession. Because what we need is just very limited. All we need is what the information we need is readily available. Once a person has died, we need, after the grieving period, we need, if it's a man, for instance, there must be a widow. If there is a widow, then the widow will come to us with a letter, a chief's letter. The chief's letter will indicate that the deceased so-and-so was a resident of my location. He died on this day as per the death certificate, and then he left the following as his dependents: wife, Jane Njoki. Children, mpaka mwisho. He may not be able to say anything about the property. That's all we need from the letter of the chief. So once you have that chief's letter, and then you have a death certificate. The death certificate is just to establish that it's true, the person is dead. And then all you need is that you come to us, give us, there are forms which you fill at then. The forms they just indicated there's form names, the deceased name, then when he died, his dependents, the people who children and wife and children, and then you indicate the property which he had. That is the first thing. Once you have done that, then you give us 2,000 shillings for fees, and then you give us 3,500 you pay to the government printer to print, to gazette. And then once we have done that, we gazette the petition. You come back, we issue you with a grant. A grant of letters of intestate is to enable you now to have the person we have appointed now, we call the administrator, to take charge of the estate. Know what properties, which other properties are in the estate which were not included. Manage some of the assets of the deceased before the full grant. Once we have given you, we give you 6 months to do that. Get all this, and then within 6 months you get us what we call summons for confirmation. Summons for confirmation is just say, I am the administrator. We have identified the property of the deceased. Now we have confirmed it's ABCD, and the dependents of the deceased are this widow, these children, and then we have agreed that we want to distribute this property as follows.
Okay.
One, the firstborn to get this, the second one, or even say equally. You work all of them, and then you say we have agreed each of us to get equal share of what is there. Once you have done that, you come back to us now for hearing what we call confirmation of the certificate of confirmation hearing. Then you come to court and tell us, look, we have agreed. I'm so and so. I'm the wife of the deceased. We have agreed on the mode of distribution. We have consented to this, and we have filed the consent. And we will want you to give us a confirmed grant, certificate of confirmed grant.
Okay.
We give you that day.
Immediately. Okay.
And then once we have given it to you, unapeleka kama ni land, unapeleka kwa land. Kama ni kwa shares za Standard Group, unapeleka kwa whoever the administrator is, and then they are changed. So now, for this, coming to your question now, the one I've described is a process which is not contested.
Okay.
And we have realized, and the Honorable Chief Justice has realized, that some of these which are issues which are not taking time, we give them far dates because we mix them with the other matters. So she said, look, can we have a special service week for these matters which are not contested, so that we can finalize with them and they leave our system and people go on and live with their lives, and then we release the so much of the funds held up in this succession within a short time.
Okay.
And that's why what we are doing from Monday 26th to 30th.
Yes.
How many cases are likely to be dealt with in service week?
We are doing this in all the high court stations in Kenya. I know in Milimani, where I sit, we are doing 700 matters next week.
Okay. And all are digital, virtual?
Virtual.
Okay.
The process is virtual. So that's what we are doing.
How does that compare to the number of cases that are pending that can actually be moved out really quickly? If one court is doing 700?
Yes, if we did the 700 in Milimani, where I sit, we'll be having less than 300 remaining for that, which are in that category.
Okay.
And the ones in that category are the ones which are not ready.
Okay.
They have not filed the summons for confirmation. They have not filed the consents, and that's where they are waiting. But if they have, if there is anybody who has, we want you even today, call the registrar and say, I want this matter to be heard on Monday next week, and we'll give you a date next week, and they will hear you.
Justice Riechi, whose business is it then to sensitize Kenyans on this process? And it's advisable to use a lawyer, isn't it? Or how do you make it accessible? Because you can sensitize, and then comes in the cost, and the cost factor. Is this affordable? Is it a very time-consuming process? How do you sensitize so that you can incentivize more people to prepare their wills and appreciate that the process works?
I think it's a responsibility for all of us. Judiciary, lawyers, public servants, whoever has an opportunity and an influence on people, to advise them that this is the best way to go. Yeah. And with the time, people are going to get to it, just as we have embraced technology. Next few years, we'll be embracing that nobody will be without a will. I mean, it will catch up like it has done in the other countries, in the other developed countries.
As you look into the weekend, dispensing with a lot of these cases that are uncontested, the issues then, around some of these cases are still front and center for a lot of people. And one of those matters, because we engage quite, thoroughly with folks who then are tuned in. And one of the matters is that something that we assume a lot in society, that if there is a child, if there is offspring, whether that is within a formal union or not, that those offspring have direct access to property or to whatever may be put in a will of the deceased person. Now, if this deceased person has put out a will and this offspring have not been included in the will, do they have rights of access to the property by virtue of them being a child, whether from a formal union or, as is often the case, an external union from what is recognized by the law?
I want to answer your question on two issues. One, if for any reason in the will, written will, a dependent has not been included, the testator didn't say anything about them, they just left them out.
Or maybe they didn't know they existed.
Or even they didn't know they existed. There is provision, and once you demonstrate that, there is provision in the Act which provides that the court can make provision for the person who was left out from the estate of the deceased, despite this will. They will make provision for that.
Okay.
That one is provided for. Where a person has indicated, these are my children, John Mburu, I don't want to give him anything. Why? Because he cut my hand. He assaulted me and I had my hand cut off. That is different. Where he says, I'm not providing for so and so, Mary. Why? Because I bought a house in Kilimani. You know, that we respect that. You have left them out in the will, but you have indicated the reason why you have left them out.
Okay.
Where you have left them out and they are not your children, they are biological children, then the issue will be, are these your children? Is this, if he's not biological child, or the child of the lady, the widow we know, but was left out, as we do, then you will have to determine first whether this one who was left out was a biological child.
So it's not automatic?
If he's a biological, if he's a child, biological, or he had taken him up as a child, parental responsibility, then we must provide for him. Yes.
Okay.
Yes.
My question is, what happens, and I don't know whether you've handled this, are there cases where there are rulings from religious courts that have clashed with, the constitutional rights of those ones who should have been included in the will, and how do you resolve them when there's that clash?
Yes. Our brothers and sisters who profess the Muslim faith, they have the Qadhi's court as the primary court where the issues of marriage and succession are done. But the law provides that if you are dissatisfied with what is in the ruling of the Qadhi's court, then they have to appeal to the High Court. And the law provides that when we sit in the High Court in appeal on a matter from the Children's Court, we have to sit with two Qadhis. I'm a judge. I have very little knowledge about the Muslim law, so I sit with two Qadhis who guide me on the Islamic part, and then we deal with it under the Constitution. Yes, we do.
There's a growing trend. I don't know if I'm the only one who's seen this, where you have wealthy families who use private trusts,
yes,
to sort of bypass scrutiny or bypass public scrutiny. And in your opinion, as a judge, do you think trusts, as they're constituted, are currently now being used to shield wealth, from either legal or from tax responsibilities or accountability, for that matter?
Trusts are instruments of succession. You form a trust. You don't want to do it specifically. You form a trust and say, look, these are the trustees. Please manage my various amount of businesses so that the beneficiaries can be able to benefit. The good thing with trust is that you entrust this one to people who have knowledge of the industry. You may be having children who have no idea about what you are doing, and most of us, our children don't know what we do, and particularly in business. So it's a very good instrument. Properly used, it is an instrument. But I don't know the aspect of concealing some taxes that doesn't concern us, concern me as a family division judge. It may attract the attention of the commercial division of the High Court.
I was asking for your opinion as a judge. What do you think?
For me,
is it
properly used, it's a good instrument for managing your affairs after your death.
There's somebody was asking, can you wheel out a loan?
You're worthy.
Like the answer, it's come really quickly in terms of
you
that.
cannot wheel, just the same way huwezi kupatiana mtu Standard Group hapa share zangu zote. You cannot. And also you cannot, it's difficult to will something which is, for instance, if the house has a mortgage with a bank, you cannot say now that one I give it to so and so. Why? It's not free property. Free property must be the one which you can sell at that time when you are alive. You have the capacity to dispose of and manage any other way. So if there is the property is mortgaged in a bank, we will not distribute it. Why? Because that is property which is now held by a third party. Once the loan is paid, then you can come and say, look, we have cleared the loan from housing finance, the property is free now, you distribute. But we cannot distribute at hiyo tumepatia mama.
So hang on, that's interesting. So if somebody has a piece of property, they've bought my 50 by 100.
Yes.
They have a loan of $1 million left.
Yes.
And then they die.
Yes.
But that's their purchase. They've purchased the property.
Yes.
So they can't include that in the will, despite the fact that it still has a balance.
Title deed iko wapi?
It's in the bank.
So what happens then to that property?
That property munalipa loan, mnamaliza, inakuwa free, mnakuja mnatuambia tunataka kudistribute. Musipolipa loan, bank inauza, hakuna kitu tumedistribute.
How is it recognized in the succession process though?
Sorry?
Is it recognized in that succession discussion?
One of the things we do is you have to give us documentation about title. And if you don't have the title, we will have the search certificate. Will show that the property is mortgaged.
So you need
and we'll leave it out.
So you have a document that shows all the list of assets and liabilities.
And liabilities, yes.
To support the to support the will or the process.
Thank you. We do. In fact, in that form, you indicate even the liabilities.
Okay, so. Looking at some of the other issues, we're looking at a lot of succession cases that are in court and that have been in court for 20 years.
Yes.
What would make a case of that nature remain within the courts for so long?
Disputes within the family. Disputes within the family. Siblings, widows, third parties, the cause of all that. And deliberately, for some others who, particularly those ones who are benefiting from that status, they don't want it to be, and they don't want, they may not want it to be determined. But we do, where we notice that, we do dedicate those matters. We determine the issues, and then it gets over our system.
Where you have disputes, and a lot of these disputes, of course, are around the distribution of this land.
Yes.
Some of them will have to do with land registry documentation and things like that. What interventions do you take to enable these resolutions, especially in the case maybe there's an attempt to, we've seen a lot of land, in fact, cartels or trying to grab land. So this property that has been willed, either that is being administered, may be subject to grabbing through this long drawn-out process.
Yes.
What can you do?
Let me put it this way. If you are a Kenyan, sincere Kenyan, and the property which you are interested in is in the name of the deceased, and succession has not been done, please leave it. Leave it. Why? Because whoever is trying to give you this parcel of land, either by sale or by whatever means, has no title, and will not recognize him at the time when we are doing the distribution. Occasionally, we do recognize purchasers, people who bought land or property from the deceased himself when he was alive, but he had not completed the process of transfer. We recognize them as purchasers. That one we do. But after he has died, the problem is the person you are dealing with is not the owner. Yes. Some other thing which we are trying in matters which have taken complicated, have taken long. And realization that these are family issues. That the goal of any court and of any person and what the deceased would have wanted is to have a stable, peaceful, and harmonious family. So when we realize this, we find that let us try mediation.
Okay.
We tend to refer, even these matters which we have talked about.
Yes.
We have referred them to very good mediators. Who try and understand and they don't go to the legal technicalities. They want to what is good for everybody, and they come up with an agreement, a mediation agreement, and we adapt it fully as a basis for distribution. Where they have been successful, and I'm happy. Some of our very good mediators are religious people. Very high understanding within the society.
Yes.
So we do that. At the rural areas, sometimes we stand, okay, do you have a clan chairman? Is it an issue which can be dealt with the clan chairman as a mediator? Then he can be able to reconcile the parties and they come to us.
Yeah.
Yes.
In the event that during the life of the deceased person, and I think that our natural inclination is to assume that, property succession or, is just the purview of the man. But in the event that an individual during their lifetime has decided that this property or that who should succeed them is not a member of the family for whatever reason, and that they decide, as we have seen often, that people can leave their wealth or their property to a church or to a school or to somebody who influenced their life. And after their death, as we've often heard, there is contestation of that because there could be dependents. There are those who imagine that, they should be able to live off of what their mother or father or whomever left behind. Can there be a contestation of that if the dependents come into the arena asking for some kind of livelihood, when it is clear what the will said that it should go to St. Bartholomew Church or whatever?
Please, that is perfectly. We respect what I said earlier, testamentary freedom. Your freedom, your property. You can pay anybody you want. Isn't it? When you are alive, you can give to anybody you want, isn't it?
Yes.
And even by will, you can give to anybody you want. That's a mental freedom. But please, when you are doing that, tell us why you have left out the children.
Okay.
Please, in the will, tell us whatever. This is the reason why I have left. I have decided I have left this so and so out, and I've given it to so and so because of this reason. We will respect that.
Okay.
Yes.
All right.
Very quickly, just some clarity. The validity of a will, you talked about it must be written, must be signed, there must be 2 witnesses. Must these 2 witnesses know the contents of the will, or they just need to know, okay, you've done the will, you've just signed. They just verify you've signed?
No, they just verify that you signed the document.
They don't need to know the contents.
They can know, but they may not didn't know. That's not important. So we don't ask them whether, did you know what they said? No. What we ask them, did you see him when he was signing the will? Yes. When was it? Where was it? And that's all. And they indicate their IDs there. Something else I wanted to say about even before we die. Have we organized ourselves properly in the event that you become unwell and incapacitated? You have not died. You have business, you have property, but you reach a time you are not able to manage your own affairs. Alive still. Have we ever thought about it? Who, for instance, will take care of take you to hospital? That is, we don't. Sometimes we assume our spouse will do that, our children will do that, and but that's okay. But even then, you have the money in the bank. You have fallen unwell. You have been rushed to Nairobi Hospital. Nairobi Hospital, they say, okay, fine, this is an ICU case. Yes, we need a deposit of this much. I mean, you have the money in the bank, in Barclays and everywhere else, but nobody can access it.
Indeed. Those are the
Spice up your life.
And we're glad that you're able to join us for that conversation this morning on Justice Thursday. The Justice, Stephen Riechi, has been here with us this morning. I've been looking at High Court Succession Service Week, all you need to know. And these are some of the issues. Thank you so much for being here with us this morning.
Thank you very much for giving us this opportunity. Thank you for spicing my day.
Asante sana.
This is the Situation Room, the only way to start your day.